Good afternoon, everyone, and welcome to IP 2020, refocusing on intellectual property. Before we formally start this afternoon's webinar, may we remind everyone that you are free to type in your questions through our chat box. And let us start this afternoon's webinar with a prayer and the Philippine national anthem.
Mga kababayan, ang pambansang awit ng Pilipinas.
Kayang magiliw, kailas ng sinanalan, alam ng puso, sa titik mo'y buhay. Lupang hinirang, tuyag ka ng magiting, sa manlulupin, di ka pasisingil, sa nagatak tutok sa simoy at sa langit mong bangaw, ay hinatang tulang awit sa pagkayang minamahal. Ang isla ng matawad mo'y tagumpay na nag-iingin, ang bituin at araw niya kailan pa may di magdidinig. Luman ang araw ng walhagin pagsinta, buhay langit sa piling mo. Ang hindi kaya na pagkay mga amin, ang mamatay ng dahil sa'yo.
To formally welcome us in this afternoon's event, let us welcome the Director of University of San Agustin, ITSO, Dr. Assam El Baghdadi.
Good morning, everyone. How are we today? I hope we are all well and safe and much warmer than I am here in England. It's freezing. My name is Dr. Assam El Baghdadi. I'm the Director Head of the ITSO office at San Agustin University. On behalf of Father President Comentador and Professor Jonel Saludes, I would like to welcome you all to this webinar. This webinar this morning is about refocusing on intellectual property. This is almost our last event of the year, but I promise you it will be very interesting and very informative indeed. We have two esteemed speakers here today to talk to you. The first is Ms. Marianne Bebet, and she is the IPSO officer, and she will be speaking to us about the basics of IP and recent update from IPOFIL. And then we have attorney Anfred Paines. He is an intellectual property lecturer at the University of San Agustin College of Law, and he will be discussing the copyrights, online infringement, and plagiarism. I hope by the end of this webinar that you will gain a greater understanding on general information surrounding intellectual property, and also to be able to understand the difference between IP violations in context of our new normal, particularly concerning online classes and social media influence. I wish you a very good time today, and I hope this will be a valuable session for you, and please have fun and enjoy the meeting. God bless you all. Thank you.
Thank you very much, Dr. SM El Baghdadi. And this afternoon, we would like to remind everyone that if you have questions for our dear speakers, you may feel free to type them through our Zoom chat box so that they will be properly addressed later on. We have two speakers this afternoon, one representing the Intellectual Property Office of the Philippines, and the other one is representing the University of San Agustin. Our first speaker is the field specialist from the Intellectual Property Satellite Office here in Iloilo City or in Region 6. She's an alumna of the University of San Agustin. Let us welcome this afternoon Miss Marian Tahanlangit Bebit.
Good afternoon, everyone. It is my pleasure to be a part of this event of my dear high school and nursing alma mater. I'm here to give you a quick overview of the lead agency responsible for registering intellectual or IP rights. That is the Intellectual Property Office of the Philippines, or IPOPHIL. Also, I will be providing you with the latest general picture of IPOPHIL's initiative that in many ways have contributed to ramping up innovative activities in the country. The Philippines intellectual property system dates back well into the Spanish and American colonial periods as early as 1879. The first known copyright law, which is a Spanish law on intellectual property, was approved. This event gave Philippines the reputation as among the first Asian countries to adopt a law on intellectual property, or IP. In 1997, the IP Code of the Philippines, known as Republic Act 8293, was signed into a law and took effect on the 1st of January in 1998. At present, we are headed by our Director General, Attorney Ruel S. Barba, and we have this newest bright mandate, which is to build collaboration and partnerships, raise the ante for customer service, integrate IP awareness, going back to basics, highlight human capital, and transform IPOPHIL into a fully digitalized agency. The IP system pertains to the rights and obligations as well as privileges and incentives, all rooted from the creation and protection of IP, which refers to creations of the mind, inventions, literary and artistic works, symbols, names, and images used in commerce. These are just among a few of the functions of IPOPHIL. The IPOPHIL grants patents, then registers trademarks or service marks, technology transfer, utility models, industrial designs, and integrated circuits. We also do disputes resolution, adjudication of administrative cases affecting IP rights, coordination with other government agencies and the private sector, and undertakes enforcement functions. IPOPHIL also exercises visitorial powers to establishments and businesses, the accreditation of CMOs or collective management organizations like the PhilSCAP for musicians and singers, among others. Now, why promote and protect IP? There are several compelling reasons. First, the progress and well-being of humanity rests on its capacity to create and invent new works in the areas of technology and culture. Second, the legal protection of new creations encourages the commitment of additional resources for further innovation. Third, the promotion and protection of intellectual property spurs economic growth and creates new jobs and industries and enhances the quality of life and enjoyment of life. This according to the World Intellectual Property Office publication. Now, the IPOPHIL recognizes that effectively harnessing the IP system towards economic development is a coordinated nationwide undertaking. And so, to extend its services and capture IP creators outside of Metro Manila, IPOFIL maintains a network of intellectual property satellite offices, or IPSOs, throughout Luzon, Visayas, and Mindanao. Housed in the Department of Trade and Industry, our staunch ally in IP advocacy, and there's also one in Vigan, which is currently housed by the local government unit. We have a total of 16 satellite offices, and the one in Western Visayas is being manned by yours truly. We are at the DTI building beside Sunburst Park, which is the old Freedom Grandstand. IP can be found anywhere since it isn't any creations of the mind. So now here's a representation of the IP rights, which is divided into two: industrial property, and on the other side, the copyright and related rights. Now, we usually use the terms like invention, patents, trademarks, and copyrights interchangeably, but we need to have a delineated understanding of these terms. We'll look into the term patent first. So, patent is the right granted by the government to an invention. It is a title or license provided by the government to conferring a right for a given period to an inventor to make, use, or sell the invention or the technology. Like, for example, invention is up to 20 years. For short or petty patents, termed as utility models, it is up to 7 years. And for patent designs or industrial designs, it's for 5 to 15 years. So what will happen after that period? We will talk about it later. And so to recap, the product invented is called the invention. The right granted to the inventor or the maker is called the patent. And if said product will be marketed and will be tagged carrying a certain brand or logo, the term now to the brand is trademark. Trademarks is another type of IP consisting of recognizable sign, design, or expression which identifies products or services of a particular source from those of others, although trademarks used to identify services are usually called service marks. On the other side of the spectrum, the second type of IP probably is where you would most likely be more interested in as researchers and educators, is the copyrights and related rights. But before we deal with the specifics, just a summary of the types of IP in one photo. Here, the product is a plant-producing writing instrument that is the invention seeking for the grant of patents. The brand of the pencil is Sprout. It is now a registered trademark. And the instructions in the product catalog is the copyright. Now for IP updates. Even prior to this pandemic, our office has already adopted electronic filing and processing of trademarks and patent applications. The global health crisis added a new dimension to our services, that of providing safer services to our clients and employees. Our Director General, on his speech with PASCO, cited that IPOFIL has transitioned to the new normal founded on one very important element: the optimal use of technology, particularly information technology and infrastructure, to serve both our local and foreign stakeholders. He further emphasized that our office has completed the deployment of an end-to-end electronic processing of IP registration and protection services, from online filing and payment until grants of IP rights, which started as early as 2016. Now, the electronic system for mailing of office actions and submission of replies and documents by applicants were fully deployed for the Bureau of Trademarks and Patents. We also have the mobile application known as IPOFIL Mobiles, which can be downloaded in App Store and the Google Play Store. Spread out all over the country are over 100 Innovation and Technology Offices, or ITSOs, and the University of San Agustin is one of the most active ITSO franchises. Now, I will provide you with the tools that you need to do in order to protect your online resources and modules through the copyright system. So what is a copyright? A copyright is the legal protection extended to the owner of the rights in an original work that one has created. How is it acquired? Works are protected by the sole fact of their creation, irrespective of the mode or form of expression, as well as their content, quality, and purpose. The protection is automatic from its moment of creation. Please note that the expression of an idea is protected by copyright, not the idea itself. Now you might ask, do we need to register these works? The answer is there's no need to register, but the author or creator deposits their work to the National Library of the Philippines or to the IPOPHIL so that we can provide you with a certificate of recordation and deposit, which is very important as this will serve as your major proof of ownership. How will you do this? We now have the online capability of accepting copyright deposits. You will just have to create your files in PDF formats and submit it either to your ITSO office or to me or directly to the Bureau of Copyrights and Related Rights, or the BCRR. The fee is $560 for original applications. So what will you need to do? You just have to prepare the application form and the affidavit of ownership and a copy of your government-issued ID and your work in PDF format. So if it's a software, you can submit also the exe file. Okay, so I will discuss on the open forum later how to avail of the other rights if you are interested on it. Thank you very much and have a nice day.
Thank you very much, ladies and gentlemen. That was Ms. Marian Tahanlangit Bebit, the IP Field Operations Specialist of the Intellectual Property Satellite Office Region 6 from the Intellectual Property Office of the Philippines. If you have questions regarding her lecture, feel free to chat them through our Zoom chat box, and we will try to address these questions one by one later on. Our next speaker is, of course, the founding partner of Panes Law, located at 70N Building, Halandoni Street, Haro, Iloilo City. He finished his Master of Laws degree from the University of Santo Tomas. He's a full-time lecturer of the University of San Agustin College of Law, and he is also the lecturer of intellectual property in the said college. Ladies and gentlemen, Attorney Anfred Panes, LLM.
Good morning, ladies and gentlemen. My name is Attorney Anfred Panes, and today my lecture covers intellectual property law and copyright. What is copyright and intellectual property law? Let me start discussing with the concept of what is copyright. Copyright is a legal protection extended to the owner of the rights in an original work, which refers to every literary, scientific, and artistic production. I'd like to emphasize that what is contemplated by the law that is protected legally covers literary, scientific, and artistic productions only. It is a right granted by a statute to the proprietor of an intellectual production to its exclusive use and enjoyment to the extent specified in the statute according to the case of Ulanio. It also refers to finished works and not to mere concepts, according to Joaquin versus Verlon. What are the general principles that you need to know about copyright? First, works are protected by the sole fact of their creation. Second, protection extends only to the expression of an idea and not the idea itself, meaning it limits the scope of copyright protection by differentiating an idea from the expression or manifestation of that very idea. Third, the copyright is distinct from the property in the material object subject to it. And finally, copyright, like any other intellectual property rights, is a statutory right. What do we mean by statutory right? By way of giving you an example, if you buy an item from a company, you have a statutory right to get a refund within a certain period of time if the item turns out not to be what you wanted. That is an example of a statutory right in relation to the fourth basic principle of copyright. You may ask, what are copyrightable works and what are those not covered by copyright? Those covered by the copyright includes original works and derivative works. What are original works? A work is considered original if it is an independent creation of the author and if it must not and the same was not copied from the work of another person or another author. He must have created it based on his own skill, based on his own labor and judgment, without directly copying or evasively limiting the work of another person. On the other hand, it is called derivative work because these are creations that are based on an existing work. For instance, the series of film of Harry Potter is a derivative work of the novel of the same title by the author J.K. Rowling. However, what are those non-copyrightable works? It includes the following. First, unprotected subject matter that refers to any idea, procedure, or system, and others that are not in tangible form. Works of the government of the Philippines are those that are covered in the public domain or news of the day and other miscellaneous facts having the character of mere items of press information. And some other useful articles such as, for instance, original decisions of courts and other tribunals. If you've been granted a copyright or you're now called a grantee, the following are your rights. You have economic rights, you have moral rights, and of course, if any of these rights are actually violated, you have the cause of action to go to court to enforce the same. Right to transfer, assign, or license, just like an ordinary holder of a title of a land, for instance, he or she has the right to convey the same. And so is a copyright owner. He has the right to transfer, to alienate, to assign, and to license said right. The rights to proceeds on subsequent transfers and other related rights, or what we call neighboring rights. As a general rule, if you've been granted that copyright, you can enjoy it for 50 years, except if it refers to applied art, which is limited to 25, and in broadcasts, which is limited to 25 years from the very date of broadcast. Let me proceed to a more practical and relevant topic, which is infringement. Infringement, in the context of my lecture, refers to intellectual property or copyright infringement. A person infringes a right under this act when he directly commits an infringement, he benefits from the infringing activity of another person who commits an infringement if the person benefiting has been given notice of the infringing activity, and he has the right and ability to control the activities of the other person. And with knowledge of infringing activity, induces, causes, or materially contributes to the infringing conduct of another pursuant to RA 8293, Section 216. It also includes the act of any person who, at the time when the copyright subsists in a work, has in his possession an article which he known or ought to know to be an infringing copy of the work for the purpose of selling, letting for hire, or by way of trade offering or exposing for sale or hire the article, distributing the article for purposes of trade, or for any other purpose to an extent will prejudice the rights of the copyright owner in the work, or trade exhibit of the article in public, as mentioned in Section 217, Paragraph 3, RA 8293. In other words, IP rights are infringed when a work protected by IP laws is used, copied, or otherwise exploited without having the proper permission from a person who owns those rights. Examples of copyright infringements are acts of counterfeiting and acts of piracy. Next topic is applicability of copyright law in social media, referring to Facebook, to YouTube, Instagram, and Twitter. Is it applicable? Is the concept of copyright applicable in social media? So the answer is in the positive, yes. Works published online, whether on a web page or on social media platform, are generally protected by copyright and or related rights. One may generally need to obtain a permission from the right owner before using it. Exception is if it is part of public domain, and if it is an example of a fair use. Hence, the secret here is if you wish to use the same, you just have to ask permission from the author or from the owner. And once granted, then that's your authority to actually post it or to avail of the same. Let me share my personal experience. When I opened my law office, I actually used the official soundtrack of Game of Thrones, and I uploaded it on Instagram, only to realize that it was taken down immediately because Instagram notified me that I might be violating any copyright law, presumably owned, of course, by the Game of Thrones management and the like. So, yeah, it served as a lesson for me, and from then on, I did not post anything that might infringe any copyright law belonging to a person or to an entity or an institution. Signing up to use social media or other digital platforms, one is bound to the terms and conditions of use, hence allowing the platform or service a non-exclusive license to use one's content. In other words, depending on their concrete terms, the platforms may have the right to use the content that a person generates or posts. In other words, depending on their concrete terms, platforms may have the right to use the content you generate or you post. Can copyright infringement be committed online? Answer is yes. The wealth of significant case laws on infringement are very much applicable to online infringement. In the latter part of my lecture, I will discuss jurisprudence or case laws in relation to infringement. Copyright, in a strict sense of the term, is purely a statutory right. Being a statutory grant, the rights are only such as the statute confers and may be obtained and enjoyed only with respect to those subjects by the persons or on terms and conditions specified in the statute, as held in the case of Joaquin versus Drelon. Further, Section 17.2 of RA 8293 provides that works are protected by the sole fact of their creation, irrespective of their mode or form of expression, as well as their content, quality, and purpose. Other Philippine laws applicable on online infringement may include E-Commerce Act, specifically Section 33, Paragraph B, RA 8792. So in relation to RA 8293, which is the very law covering copyright and infringement, you may also refer to RA 8792 or the E-Commerce Act. Section 33 thereof specifically states, piracy or unauthorized copying, reproduction, dissemination, or distribution, importation, use, removal, alteration, substitution, modification, storage, uploading, downloading, communication, making available to the public or broadcasting of protected material, electronic signature or copyrighted works, including legally protected sound recordings of phonograms, or information material on protected works, the use of telecommunication networks such as but not limited to the internet in a manner that infringes intellectual property rights. There is a penalty of a fine of a minimum of 100,000 pesos and also a mandatory imprisonment of 6 months to a maximum of 3 years. Next is the concept of plagiarism. Plagiarism as defined by the Supreme Court in the case of In Re del Castillo, a 2010 decision decided by the Supreme Court, said that it is a theft of another person's language, thoughts, or ideas. To plagiarize, as it is commonly understood according to Webster, is to take from and pass them off as one's own. In other words, you claim it to be yours. You do not cite or you do not attribute it to someone. You do not acknowledge the author who wrote the same, and basically claim it to be yours. The passing off of the work of another as one's own is thus an indispensable element of plagiarism. Is there a difference between plagiarism versus copyright infringement? Well, yes. While it may appear that they can be used interchangeably, nevertheless, the two are different concepts. So what is plagiarism? It is an ethical offense, while copyright infringement always carries the potential for legal consequences. Plagiarism is primarily about copying material without proper attribution, while copyright infringement is concerned with borrowing significant portions of a work without permission from the copyright holder, whether or not the holder is cited. Under the Intellectual Property Code, what is the concept of plagiarism? Is it punishable as a crime? Or is it only copyright infringement that is punished as a crime under the Intellectual Property Code? The act of plagiarizing the works of another bears the closest affinity to the act of copyright infringement. That's why some are confused by the use of the word plagiarism vis-a-vis the term copyright infringement or the phrase copyright infringement. Plagiarism undermines the protection accorded by intellectual property laws to authors because its effect is the unauthorized appropriation of an original idea in its subsequent presentation of the plagiarist's own. However, plagiarism per se, I'd like to emphasize that plagiarism per se is not punishable as a crime under IPs unless it also amounts to copyright infringement. So it is safe to conclude that it is copyright infringement that is punishable as a crime and not plagiarism itself. Next is the concept of fair use as, again, an exception or one of the exceptions of copyright infringement. Section 185 of Republic Act 8293 states that the fair use of a copyrighted work for criticism, comment, news reporting, teaching, including multiple copies for classroom use, scholarship, research, and similar purposes is not an infringement of copyright. As I've said, it is an exception to to copyright infringement. Now, let me discuss the principles or the doctrines laid down by the Supreme Court in a number of case laws. We start with Co versus Court of Appeals, decided by the Supreme Court in 2002. The scope of the copyright here is the difference or the distinction between copyright and trademark. The court ruled that the scope of a copyright is confined to literary and artistic works, which are original intellectual creations in their literary and artistic domain, protected from the moment of their creation. This is a clear example of the very definition of what copyright is about. This is the interpretation of the Supreme Court as laid down in the case of Co versus Court of Appeals. The name and container of a beauty cream product are not proper subjects of a copyright. Another is a relevant case of Microsoft versus Manansala, a fairly new jurisprudence or case law decided by the Supreme Court in 2015. Printing or copying was not essential in the commission of the crime of copyright infringement. Only selling of pirated computer software constituted copyright infringement, and computer programs are covered by copyright protection. So some of us may avail of free software downloads. Okay, some of us are actually availing of the same. We might not realize that we are already violating the copyright or the rights or the intellectual property of another person. Supreme Court said that the gravamen of copyright infringement is not merely the unauthorized manufacturing of intellectual works, but rather the unauthorized performance of any of the acts covered by Section 5 of PD number 49. Hence, any person who performs any of the acts that qualify as infringement without obtaining the copyright owner's prior consent renders himself civilly and criminally liable for copyright infringement. Computer programs are covered by copyright protection. Another is the case of Sambar versus Levi. This is about copyright cancellation, and the registration of a copied design does not confer originality upon a copycat version of a prior design. So, in other words, is a copycat version of the original copyrightable? Is it also protected? Well, I think the answer is obvious. Petitioners, Europe Press, accurate design is a copy of Levi's, therefore it warrants cancellation of its copyright. The essence of copyright registration is originality, and a copied design is inherently not non-copyrightable. If it is non-copyrightable, therefore it is not protected under the law. Another is the case of Habana versus Robles, a 1999 decision of the Supreme Court. This is fairly the same doctrine as laid down in the prior case. We're talking about an original version versus, of course, that which is a copycat version. The Supreme Court further said that in infringement, copying alone is not what is prohibited. Rather, the act of copying must produce an injurious effect. So you have to convince the court that indeed the act of copying or the output of the same produces injurious effect. Okay, before you can actually claim anything or before you can lodge your complaint before the courts. UPBOR versus Court of Appeals, a 1999 decision of the Supreme Court, talking about academic institution of higher learning has academic freedom as enshrined in the 1987 Philippine Constitution. Plagiarism in violation of the rules of an academic institution warrants the cancellation of any degree conferred by it. Institutions of higher learning can decide who can and who cannot study in it. It certainly can also determine on whom it can confer the honor and distinction of being its graduates. Nothing could be more objectionable than bestowing a university's highest academic degree upon an individual who has obtained the same through fraud or deceit. I received a number of questions prior to my lecture, and I'll try my best to answer them. The first question is to differentiate plagiarism from copyright infringement. I believe I've discussed this thoroughly in my slides. And a copyright infringement is the act that is being punished under the IPR and not plagiarism per se. In terms of nature of the act, plagiarism is primarily about copying material without proper attribution, while copyright infringement is concerned without borrowing significant portions of a work without permission from the copyright holder, whether or not the holder is cited. Another question, what are copyrightable works? I've actually listed down what are original works vis-a-vis derivative works. And just to reiterate, an independent creation of the author, and it must not be copied from the work of the other. What are copyrightable works? Work considered derivative or original are copyrightable. Now, our class modules, course outlines, class presentations, study guides, and other classroom materials prepared by the teacher subject to copyright? The answer is yes, if they are copyrightable, which means they must either be an original work or a derivative work. What are the implications if students upload in class, upload classroom materials and their class outputs on social media sites and file sharing sites? Is this covered by fair use? The answer is yes, pursuant to Section 185 of RA 8293, which says, fair use of a copyrighted work for criticism, comment, news reporting, teaching, including multiple copies of classroom use, scholarship, research, or similar purposes is not an infringement of copyright. Who owns the work of the students? Well, it depends. If the work is copyrightable, then it is by the student since it is his own creation or it is his own work. Can teacher file in behalf of the student for their class outputs, and who will be named after the students or the teacher? As a general rule, it is the owner of the work who has the right to file for registration. However, the owner of the work may transfer or may assign his right to another person, including his teacher. Are original video presentations made by the student or the teacher copyrightable? How about the recorded presentations? Yes to both questions. An original video presentation or original video presentations are copyrightable, either made by the student or by the teacher. And yes, it is also similar to the rule covering the copyrightability of broadcasts. So yes, they are subject to copyright. I think that ends my lecture. Thank you very much.
Thank you very much. That was Attorney Anfred Panes. And at this portion, we are going to have the open forum. So we have this afternoon live with us is Ms. Marian Bebit from the Intellectual Property Satellite Office of the Innovation and of the Intellectual Property Office of the Philippines. Good afternoon, ma'am.
Good afternoon, Sir Gordon, live from our office.
Yes.
Good afternoon, everyone, yung mga former teachers and sila Dean. Good afternoon.
And we also have received several questions regarding the lecture of Miss Marian Bebit and of course Attorney Panes. And we would like to address these questions one by one. And for those who are interested to know more about which part of their module or which part of their study guides or classroom materials are subject for copyright, now actually is the best time for us to ask Ma'am Bebit in order for us to be protected in this time of the new normal. So we have one question here, Ma'am Bebit.
Yes, sir.
They
Go ahead.
actually need to go, like the academe, do they actually need to go to the IPSO office for them to file their copyright?
Okay, sir. Do they need to go to my office to file
Yes.
for their copyright? It's actually no, because they have you, my ITSO office, San Agustin, and the ITSO, Sister Gordon and Sheila can assist them with the filing and the deposit. And also, meron kami, sir, may online kitagaling na platform where they can email directly to to the Bureau of Copyright and Related Rights. Pero mas okay if mag-course through anay sila with the ITSO office.
Okay, here's another question, ma'am. How about those who does not have an ITSO? Because not all universities are, or not all universities or schools or institutions have an innovation and technology support office. They are asking for non-ITSO schools who are not franchised, of course, by the IPOFIL. How do they go about filing for their copyrights of their modules?
Okay, for non-ITSO schools, yes, they can go here. There is a DTI office, or pwede man, sir, later on, ma-email sila sa akon requesting for the procedure and the form. Pwede na siya dayon ma-ubra. They can submit through email, and I will forward it to the Bureau of Copyright and Related Rights. And then, after which, they can pay sa mga bayad centers naton. So everything will be online. Or pwede man sa non-ITSO schools could go to you and
Yes.
i-forward sa akon or to BCRR.
All right. Ma'am, specifically, there's one question here specifically for study guides. According to them, study guides are actually generic in a sense. So is it copyrightable or not? Amo na ang ila pamangkot, study guides. But usually study guides is generic eh. Amo nang pagka-intindi naton when we say study guides. As contrary to a module wherein, like explained earlier by Attorney Panes, it is it should be something original and out of your own concept and all that. But usually ang study guides these are generic formats. What do you think of this, Ma'am Bebit?
Literary kag artistic work. So, hindi siya pwede maging, you could not solely or exclusively claim ownership to that study guide, kaya hindi na siya.
All right. So let me just reiterate for those, I think we experienced some technical problem. Let me just reiterate, study guides are not original, creative, and artistic works, so these are not subject to copyright. However, they're modules. They are subject to copyright.
Yes, correct, sir.
Another question here, actually, nasabat na ni siya ni Attorney Panes earlier regarding materials that are online. According to Attorney Panes earlier, it was stated that everything that is being shared online is, of course, subject to copyright, except for materials that are of public domain and covered by fair use. Okay, Ma'am Bebit, there is a question. Does all business or enterprises, do they need to file for trademark protection?
Okay, very good question, sir. No, it goes to the discussion on the difference between the business name, which you get from the Department of Trade and Industry, and the trademark, which is from IPO. So, ang question niya, is it required to get a trademark? The answer is no. But the main difference is that if you get your trademark, you get additional protection, especially kung ang imo, sir, nga ngalan, comes with a logo or my design. So sa business name, your name per se, Gordon Restaurant. Ang Gordon Restaurant, na-register mo na siya with the DTI. So the name na pwede ma-type is protected by the business name law. Whereas kung butangan mo siya logo, like caricature, bisang face ni Sir Gordon, the logo with the name will be protected under the trademark law. So wala na may masunod sang the name, the combination of the design and the brand mo if you go through the protection or registration of the trademark. So it's not mandatory to get a trademark, but it's an additional protection to your company or to your brand.
All right, ma'am. Thank you. One question here from Dr. Dakila. Is the cost of copyright the same in Manila and in locality?
Okay, hindi sir.
Or
It's
locally?
different from National Library from the National Library of the Philippines. Subong daw free ang wala sila charge. Before it was 200 pesos. And then when you file, if you are based in Manila and then you file dito sa head office namon in Taguig, you will be paying 460 pesos. But sa regional, you will be maybe next year may adjustment sa fees.
Yeah, so that's 560 for copyright applications locally. All right. Now, if I upload my work to Scrib and other file sharing site, is it tantamount to waiving my right to copyright? Based on our understanding, sa mga Scrib, these are covered by copyright per se, but certain aspects of Scrib materials is subject to fair use. So kung for research and educational purposes siya, that's subject to fair use. Kag I think if you register sa Scrib, nagabayad kay. So, and then there's also the file sharing aspects.
Yes, mas better sir kung i-review nila ang terms and agreement nga before they upload with Scrib kay may ara na dira sa user guidelines or disclaimer when you upload with Scrib, you are sort of waiving your right kay all mga disclaimer na ba lang click kita accept. Okay.
Correct.
Kay may mga clauses dira nga which are very important.
So again, to reiterate, review the terms and conditions and to make sure that you understand the terms and conditions ang inyong file sharing sites. Okay, good afternoon. I would like to ask if we include definitions in our modules and concept from online or internet, can we still apply for copyright? General definitions, I believe, is covered by amo nang ginahambal nato nga public domain. So there are certain generic words nga not subject to copyright. But there are other terms, like for example, kung unique term na siya nga gin-create mo, I think siguro you can file that for copyright. What do you think, Ma'am Bebet?
Correct, sir. If it's a unique term or made-up term like ang subong mga pet malu, maybe pwede mo na siya ma-apply ng copyright or i-trademark mo siya ang word na create mo as new and something na i-own mo, but not the generic term.
Yes. Okay. So I think we have another question. Can we copyright a software process model or enhancement of certain algorithms? Ma'am Bebe, I think we can do that, right?
Yes, ang robot and the software could be patented.
Yes. So again, to reiterate, the algorithms is copyrightable. The robot is pwede siya maging utility model or invention, right? Depende sa kung anong nagsulod siya sa inventive step or is it novel, right? So, but usually algorithms and software processes are copyrightable. Okay. And I think before we leave, actually, Ma'am Bebet, we are going to give out shirts sa aton nga participants. So part of the Intellectual Property Office's move to encourage everyone to participate in championing intellectual property is, of course, gapanghatag kita sa shirt so that when you can actually wear it on a regular basis para ma-encourage ang iban to really champion and advocate intellectual property. So I am joined here this afternoon by our ITSO admin assistant, Sheila. So we will have the wheel, right? Okay. We have a wheel randomizer so that kung sino ang ma-take home sang shirt. Okay, congratulations kay Miss Ma'am Mary Lenore. Ma'am Mary Lenore, congratulations. You get a shirt and then we'll email you of the details kung paano namon idulong sa imong shirt. Okay, and we'll be giving out 5. So, one will be given to Ma'am Maria. All right, thank you. Congratulations. Okay, and will be another Itso shirt will be given to Sister Laarni. Congratulations, Sister Laarni. You get a t-shirt also. And congratulations to Edwin. Sir Edwin, you also won an Itso shirt. And also congratulations to Sir. So we will contact you with regards kung paano ninyo makuha ang shirt. And our Itso will be sending the link sa chat for you to have an access at an evaluation form. And the only way for you to get your certificate is if you go through the evaluation form. We'll be sending out the certificate for this afternoon's webinar after you have accomplished the evaluation form. Ma'am Marian Bebet, thank you very much for the time you always share with the University of San Agustin ITSO. And I hope that you continue to join us in all our endeavors for intellectual property.
Yes, sir. It's my pleasure to be here again with my alma mater.
Okay, thank you very much to those or to everyone who joined us this afternoon. The link for the evaluation form is found on your chat box. So kindly click on the link and then accomplish the evaluation form for you to receive your certificate. Thank you very much and good afternoon, everyone. Good afternoon, Ma'am Bebe. Thank you, Gabe.
Have a nice day. Bye.
Bye, ma'am.